Make peace of Lordship. Lordship, I beg to mention 20.
Yes, sir.
Lordship, I may be allowed to place the compliance order.
Today,
Okay. 20 content. Yes. Lordship, here we have complied with the court's order by appointing the petitioner. So in view of this, Lordship, I pray that content may be closed.
I bring on behalf of Nancy Tota.
okay. What do you say? If it is complied,
Number 7.
There is no respondent number 6. 20, yes.
which for the petitioner?
Lordship, on the last occasion also, they did not turn up, and even today also, they are not turning up.
Who is the law council? Learned council?
Zimomi.
We'll take up some time after some time. Can you just
Okay.
inform?
Lordship.
Okay.
That's Lordship.
Yes.
Lordship, bail matter is listed for this week, Lordship, but however, the matter has not been listed, Lordship. The matter was listed on last week, Lordship, on Thursday. And however, the matter has not been listed till date, Lordship. So it's matter can get
Listed tomorrow.
tomorrow's DV, Lordship.
Then day after. It's a pre-arrest bail.
Lordship,
Pre-arrest bail or regular bail?
Lordship, it's a normal bail application.
Regular 439.
Yes, 439.
We'll see it after then in that case.
Because the orders have to one not in this week. Friday.
Yes,
Okay, Lordship, on Friday, Lordship.
Friday, not day after. Not
Thursday is
Thursday.
holiday, Lordship.
It's a holiday.
Yes, Lordship.
Okay,
As Washington, it's holiday, Lordship.
okay,
On Friday, Lordship.
okay.
Oblige, Lordship.
Your Lordship, I beg to mention item number 16 and 17.
16 and 17.
Yes, Your Lordship, state is safe to file affidavit. So can we
Okay.
grant 3 weeks time to
MS
AIM?
Learned Government Council praised for and granted 3 weeks time.
Yes, Your Lordship.
3 weeks time to file counter affidavit. list after 3 weeks.
Your Lordship, I also beg to mention item number 23 and 24 of the hearing list. On behalf of my colleague Livika,
No, this is 2016 matter,
Your Lordship, she's indisposed today, Your Lordship.
then Friday,
Okay, I'll inform her, Your Lordship.
on Friday. It's 2016 matter.
Yes, Your Lordship.
You have to understand.
Yes,
All right,
Yes, Your Lordship.
on Friday,
Yes, I'll inform her.
on the prayer of the
AIM on behalf of Livika.
MS so and so, on behalf of so and so, learned counsel for the respondent.
Yes, Your Lordship, for the respondent.
List this matter on Fridays 6/12. And then whether affidavit has been filed or not,
Yes, Your Lordship, it must have been filed, it's on the hearing.
it's in custodial debt.
Your Lordship, I'm-
There are two petitions.
Yes, Your Lordship.
One is for investigation and next is for compensation. Share with your friend will be appearing whether the affidavit has been filed or not. And read the judgment of DK Basu. 1997 1 SCC 416. And thereafter,
And Your Lordship, I beg to mention item number 1. On
One.
behalf of my colleague V. Jimo. Kindly fix this matter on after the vacation.
this also 2018. We'll dispose it today. Are you ready? Pleadings completed.
My lord, my lord.
But Your Lordship, the
What happened?
is indisposed today, Your Lordship.
Next week?
Your Lordship.
Which date? Next week? If pleadings are completed, we'll take it up for disposal next week.
Yes, Your Lordship.
There was a direction of this court to find out. I've checked up, I've read the file that you have produced the instruction that this is a case of those excess appointment.
My lord. Any day, my lord.
Your Lordship,
Any
make it
day,
on Monday.
Have you gone through Rakire? Mukul Seki and Rakire, Supreme Court judgment.
I'm not aware of it.
Then after
My lord.
summer vacation or next week? Tell us.
After summer vacation.
You read that Rakire and Mukul Saikia, Supreme Court judgment. If you want a citation, I'll give you. You come to my chamber later. Read those judgment. Otherwise, how you'll argue the matter?
My lord.
And if you get the latest beyond that, Mukul Saikia and Rakire. Rakire, you tell your friend read Rakire because it may help the government. There's an exception. Otherwise, Mukul Saikia is against you.
Actually, the main counsel is in the next quarter.
On the prayer of learned council, government council list this matter after vacation.
Much obliged.
Your Lordship, I would to mention item number 3 on behalf of additional AG. And let the matter be fixed on 4th of 7.
Okay.
Your Lordship, even my learned senior colleague is here. He's here before the Zombie Court today. So it is my humble prayer that if he doesn't want to argue today, at least allow me to finish my part of the argument.
It's pleadings completed.
Yes, Lordship.
What is the matter?
My Lord, it is for the disparity in pay scales.
Okay.
And this matter, Lordship, has been dragging on for quite some time now. So if my
Okay,
Lord
it's
may
up
kindly
for
allow me to finish my
2019.
argument today.
No, we'll not have a piecemeal. We'll hear it both of you
If not,
together.
he's here today, Lordship. The matter, it will not take that much time also to argue. The law point is limited to service, the Nagaland Police Service and the JCO, the Junior Commission Officers of Village Guards have been It has been declared as a
Joshua,
corresponding service,
Joshua,
my lord.
it may not be difficult for you. It may be seems easy, but for court it may be difficult.
My lord, it is not so. I appreciate your lordship's humility, lordship.
So when,
On fourth. Your
let us
Lordship.
give him some fourth
Yes, on Tuesday.
Tuesday.
Fix the
So
matter on Tuesday,
next
Your
week.
Lordship.
Okay,
On
lordship.
the prayer of learned council, learned state council, list this matter on 4/7/2023 for admission
No.
hearing.
Bless you, lordship.
Your Lordship, item number 6 and 7,
6 and 7.
on behalf of V. Jimo, the affidavit has been sent for vetting.
Okay.
Kindly let the matter come up after a week.
Any objection?
No.
On the prayer of learned government council, list this matter after 3 weeks
Yes, Your Lordship.
so as to enable the respondents to file their counter affidavit. List after 3 weeks.
And Your Lordship, similar prayer for item number 8 and 9. Kindly let it come up after a week.
Madam, you just give the number.
Item number 8.
8, 9.
After a week on behalf of V. Jimo.
Same prayer. After a week, in the sense, let it come after summer
Okay.
vacation.
Yes, Your Lordship. Okay, fine.
Any objection, sir? Okay, after summer, after vacation.
And Your Lordship, item number 12, 13, 14, and 15, on behalf of Inawali, state is yet to file affidavit, so can you let the matter?
What
come
is the
up?
matter? This matters
Your Lordship, I'm
and
not sure.
similar matters. This is regarding what?
Your Lordship, here, the petitioner is praying for minimum scale of pay.
Minimum scale of pay.
Yes, Your Lordship.
It's a big matter in that case. So when do you want?
After 3 weeks, Your Lordship, state is yet to file affidavit.
The learned council, state council submits that she may be allowed to file, she may be given some time for filing the counter affidavit. And the prayer not being objected to by the learned council by petitioner, list this matter after 4 weeks,
3 weeks. Your
3
Lordship.
weeks. You have to, it's a minimum pay scale.
Yes, Your Lordship.
What was that case?
Your Lordship.
Jagjit Singh,
Yes, Your Lordship.
Jagjit Singh,
Yes, Your Lordship. Yes, Your
Okay.
Lordship.
Jagjit Singh, you will have to pay after 4 weeks.
And Your Lordship, item number 10.
Then,
Yes, Your Lordship. On behalf of Ligita, Your Lordship, there's an appeal in the Supreme Court with regard to this matter, so let them.
is it, appeal is there, but there is there any interim order by the Honorable Apex Court?
Your Lordship, I'm not aware of that. So Your Lordship, let this matter come up after.
Madam, she's saying it's appeal is before the Apex Court.
Lordship,
The procedure is, even the appeal is filed, but if there's no interim order, staying order, then we'll
Lordship,
have to proceed.
Lordship, whether there is any interim order that can be
That's why I'm asking.
clarified by.
Your Lordship, as of now, the Supreme Court is on vacation, so status could not be obtained also.
That is not a, that cannot be a ground. Anyway, what do you say? If you don't have any objection, we'll grant it.
Lordship, let it come up and let her get instruction.
Yes,
Okay.
Your Lordship.
On the prayer of
Those
MS
status.
so-and-so learned counsel appearing on behalf of the Alice contender. List this matter after 2 weeks
Yes, Your Lordship.
so as to enable her to obtain instruction regarding the
Status.
SLP or SLP before the Supreme Court, Honorable Supreme Court, and its status.
Lordship,
List after 2 weeks.
obliged, Lordship.
May I place your lordship?
Yes, sir.
Allowed, I may be allowed to move an anticipatory bail application up to the listed Part one matters.
Lordship, I beg to mention, item number 20, the council has, arrived,
Yes.
yes.
Madam, you have been appointed
Yes,
and it has been complied with.
Lordship.
Anyway. Heard MS Jet Zimobi. Learned counsel for the petitioner. And also heard MS. So,
V. Shukla.
Ji Shukri, learned V. Shukri, learned additional advocate general. The learned advocate general, additional advocate general placed before this court the order dated 24 May 2023, by which the petitioner has been appointed as sectional assistant on compassionate ground as directed by this court. List of, since the order of this court has been duly complied with, the contempt petition is closed.
Lordship. Lordship,
Obliged, Lordship.
May I please your lordship?
Yes,
Lordship, I beg to mention item number 11.
11.
Lordship, here I'm mentioning on behalf of the appellant, the insurance.
Yes,
Lordship, the principal counsel is indisposed. Kindly list the matter on 18th of next month, 18th July.
no objection. You are for claimant.
Yes, Lordship. Respondent claimant number one.
Mr. Your name, please.
Dongo Sanika.
Learned counsel appearing on behalf of Mr. N. Nuksung Tila
Yes.
for applicant oblique appellant
Appellant.
who is reportedly indisposed, pressed for and granted 2 weeks.
Let it
Three
be come on
3 weeks
18th.
time. The Mr.
Imti Wapang, your lordship.
Inti Wapang, learned counsel appearing on behalf of respondent claimant has no objection. Please to list this matter on 18/7/2023.
Obliged, Lordship.
May I please, Lordship.
Yes,
Lordship, I beg to mention item number 22, Your Lordship.
22.
Yes, Lordship. On behalf of the council for the appellant, Your Lordship. Lordship, here, the service of notice has been completed, Your Lordship. So operated, this matter may come up for hearing. In the
Admission here.
admission hearing in the usual course. So it's in the order stage.
It's order stage. What order should be? We'll see after some time. It's an order stage. It's order column. Anything to be done?
No, Lordship, all the pleadings is completed.
Okay,
Since that it has been wrongly listed, it should be in the admission.
so you are representing all the
Respondent claimant.
respondents,
Yes, Lordship.
all the respondents.
No, Lordship. Respondent one.
Then in that case, there are, I think, another 4 other respondents.
Yes, Lordship.
Maybe steps might not have completed. I mean, the service or other respondents. We'll see.
Lordship.
We'll see after some time.
Lordship.
It's list is almost exhausted. We'll see after some.
May I please, Lordship. Lordship, again, beg to mention item number 4, Your Lordship. Lordship, here, we will be filing our affidavit in reply to the affidavit in opposition filed by the respondent number 1 to 5, Lordship. So operated, this matter may come up after the vacation, Your Lordship.
Okay. Mr. Your name?
Medovero, Lordship.
Your name is not here.
No, Lordship. I'm staying on behalf of my senior, Lordship, Mr. Fosako Fote.
Okay. Mr. So and so. Learned counsel appearing on behalf of Mr. Poseko Fote, learned counsel by petitioner. President, he may be allowed sometime to file
Reply.
affidavit in reply to the affidavit in opposition filed by the respondents. Praise the Lord, list after
Vacation, Lordship.
summer vacation.
Much obliged, Your Lordship.
Yes.
May I please, Your Lordship, please allow me to mention hearing item 25. On behalf of Nancy Luthat, you see the learned counsel for respondent number 7. It may kindly be listed on Monday, coming Monday, on 3rd of July.
Any objection? You are for petitioner. You are for petitioner.
Respondent number.
Respondent number 7. Who is for petitioner? What is the matter? It's hearing list. What is the matter?
I'm not very sure, Your Lordship.
You have to be very sure. Otherwise,
Yes, Your Lordship, it's a compassionate appointment.
compassionate appointment. So we'll dispose it of. You are for respondent number 7.
Yes, I'm just praying on our behalf, since he is indisposed.
You are a very, you have been appointed on a casual basis much later than the petitioner.
Your Lordship, my senior is engaged in court 1, so can you imagine that the minister on Monday?
No, we'll see after some time. How long he will be there? It's a compassionate appointment. We'll decide. Unnecessary, we should keep it pending.
Since the counsel for respondent number 7 is happened today, our interest may be affected.
Okay,
I'm just appearing on our behalf for adjournment.
on Monday. Monday,
Thank you, my lord.
on the prayer of the learned council for both the parties, list this matter on Monday is what? 3rd, 3/7/2023 for hearing. We'll dispose it on that day. Tell your seniors.
May I please, Lordship? Lordship, I beg to mention item number 21 on behalf of Supun Chan. The state is yet to file counter affidavit, so Lordship, can you list this matter after vacation?
For counter affidavit,
Lordship,
you are for
I'm for the state
state.
on behalf of my colleagues.
MS so learned state council press for and granted 3 weeks time to file counter affidavit. List this matter after 3 weeks.
Templates. Yes, Your Lordship.
Yes,
My lord, I beg to mention item 18.
18.
Yes, can you the matter may be listed on 30th?
You are for?
I'm for the petitioner, Your Lord. My lord.
What is the matter?
It's regarding promotion,
Promotion to the post of
Subidar measure.
Subedar Major. Why you have not, you are seeking promotion,
It's regarding seniority.
seniority, you are challenging the seniority or seeking promotion. You know, promotion as such is not a fundamental right, but then right to consider is fundamental right. So is it a dispute regarding seniority or the supersession?
I'm standing on behalf of my senior. I'm standing on behalf of my seniors.
Government or a respondent, private respondent?
Yes, sir.
Do you have the brief? Item 18. Whether the pleadings are completed or not?
Yes, Your Lordship.
Pleadings completed. We'll hear today.
Kindly the matter may be listed on 30 for hearing, admission hearing. Kindly the matter may be listed on 30 for admission hearing.
30.
Yes, Your Lordship.
On the prayer of the learned council to the petitioner, list this matter on 36. That is Friday,
On Friday, yes.
Friday.
Much obliged.
2010.
May it please your lordship.
Yes,
Lordship, on the earlier occasion, the insurance appellant company, it was represented by V. Derna.
Yes,
However, Lordship, he has withdrawn his Vaglanama. And thereby this honorable court was pleased to issue notice
yes.
against the appellant. So Lordship, as per the office note dated 19/5/2023,
Yes,
Lordship, the notice issued to the insurer and postal tracking has confirmed the item oblique the letter delivery, Lordship.
yes.
However, they are not present today, Lordship.
Thereafter, it was listed before this court
Yes, Lordship.
on 5th of June.
Yes, Lordship.
What to do in that case?
Lordship, this matter may be dismissed for non-prosecution, Lordship.
It's a
Yes, yeah.
statutory appeal.
Yes, Lordship.
We just
So
cannot,
we'll list
we
it
ju-
on
we just cannot dismiss like that.
Yeah, we'll list it on 18, Lordship. Admission hearing, Lordship.
Of course, there's a order that it should listed after 3 weeks for admission. We'll just give them one more chance.
Lordship, on 18, Lordship.
Non appears for the appellant on call. Mr.
There's a last chance, Lordship.
It is noticed that on 5/6/2023, also non-represented the appellant. Office note dated 19/5/2023 shows that the notice as directed by this court on 5/8/2023 to the appellant is shown to have been delivered. Mr. List this matter after 3 weeks
On
for
18th,
admission
Lordship.
hearing.
Lordship, on 18th. On 18th.
List this matter on 18/7/2023. On the as spread for by Mr.
Imti Wapang, Lordship.
M.T. Wapak, learned counsel for the
Claimant
respondent,
respondent.
claimant respondent. Respondent claimant.
Yes, Lordship. Obliged, Lordship.
Item number 5.
This is a petition for quashing
Yes,
of an FIR and an order passed by the honorable lower court below. My lord will kindly peruse this orders dated 19/6. Thus, fee was effected upon the respondent, who was the informant,
19/6.
19/6, madam. Thus, fee was taken into count, service affidavit was filed, and service was deemed to be completed. 19/6.
(19/6) of
This year, 19/6/23. The very last order. Whereby this matter was fixed today.
it's an office note or order of this court.
There's an order passed by Justice Sema.
Yes. Are you ready?
Lordship. Yes, Lordship. Started, I'm telling you a charge sheet.
Your seat.
Charge sheet arising out of GR case number 689. My lord will find that at page 12.
Page 12.
Page 12. Is a FIR and GR numbers quoted. On the chart sheet is certain numbers reflected on page 15. Sections of 509, 506, and 67A IP Act. At the top portion, I will see the GR number is there. It's in my hand.
506, 509,
And 67.
67.
And the chart sheet is at page 30, starting page 30.
Yes.
Well, to start with the respondent number 1, respondent number 2, my lord. The informant and the appellant, the accused, both are cousins, my lord. And my lord come to, and my lord, I have 3 foundations are there, my lord. There is settled, there is a settlement, deed of settlement which is brought on record. They have settled it. This is a practice prevalent here, my lord. They will settle in the presence of elders that they will not press this case anymore in future. Apart from that, my lord will come to a discharge petition, my lord had pressed. This case was at the stage of consideration charges, and there was a petition was pressed, my lord, to alter the charges. And at page 17, my lord.
Yes.
I am very aggrieved by this order. 17, it's passed by the Honorable JMFC. Yes, I will come to page 21 from
21.
21.
Yes.
Paragraph at the bottom. Can I read it? However, having perused the case record in charge sheet against the accused person against under section 172 CRPC, it is seen that the IO has not submitted any CDR, expert opinion, data history, or other relevant documents, etc., which are essential to the investigation of the case. The charge sheet submitted by the IO simply states that the report of the extraction of deleted data from the accused one is still awaiting from so-and-so Kohima. This even after 2 years since the criminal process has been initiated. It would be understatement to state that there is much left in the investigation process carried out by the investigation. On the next page, man. Bearing in the mind the nature of offense alleged, the investigating officer ought to have conducted a more thorough investigation of the offenses alleged. Even hypothetically, if we were assuming, this is important, my lord, for me, if we were to assume that this court were to proceed based on the materials available today, there will be no materials to exhibit or prove at the stage of evidence in a trial with only an exercise in futility. So my defense has been exposed, and this was at the time of consideration charges. So my lord, kindly bear with me, and I'll kindly go to page 23. The magistrate, my lord, magistrate, while considering the charges, goes on to express that if based on today's records, it will be a exercise in futility, that he has a predisposed mind, my lord, due honor. But every trial must end in conviction. And to bring home to his finding, my lord, on the page 22 itself, I will see the London magistrate has put the citations, Supreme Court judgment, man. Hari Bhai, Binu Bhai, Malakya. However, he misquoted the whole judgment, man. He takes help of the judgment, and he quotes the whole paragraph, and he, page 23, my lord, will see. Page 23, my lord, there is a, in a middle portion, if, it starts from if, my lord, there's an underlying portion. Just next to that, it's if, for example.
Yes.
There is a part of the same judgment, which is basing upon which he has ordered for, what you will see the bottom question, operative, he has sent it for further investigation, but he had excluded this matter. This, if, for example, fresh facts come to light, which would lead to inculpating or exculpating certain persons arriving at the and doing substance justice in a criminal case are more important than avoiding further delay. Because in conducting the proceeding as helping person by Valley Kudeshi, so and so stands about. This verbatim he has quoted his judgment, but in this case, my lord, If, for example, where are the fresh facts? Where is the new facts? There's no facts produced. Nothing has been divulged. Learned magistrate passes this direction with all due respect, my lord. He can go for, he can direct further investigation, but with certain parameters. The parameters set out there, my lord. There has to be some certain fresh effects, fresh facts, fresh evidence. Nothing has come.
Yes.
Yes, my lord. That is one of ground, my lord. And if my lord takes on an additional effect, I'll kindly keep lordships to page 16, my lord. Page 16 of the petition.
Yes.
16, my lord, see enclosures. There is an 8. It's written in pen written. Agreement bone, my lord. Even that compromise is also a part of this charge sheet, madam, which is not brought on record due to my fault. I didn't while annexing this charge sheet, I didn't begin record. Later part of time, madam, by filing an additional affidavit, I brought it on record. My will file it with the case report, madam.
What is this agreement bond?
My lord, they have settled their differences. My lord will come to I have I filed an additional affidavit. Affidavit on 22nd of July. Additional affidavit.
Yes.
Well, this additional affidavit, I will see, there is annexure A, page 4. It's in their own dialect, my lord. It's our language. Its translated part is on, is at page 5. Today, so-and-so, Miss so-and-so, amicably settled for police case which pending with the police, neither of us shall bring forth this case in the future in settlement in presence of Nocturnal Union, Dimapur.
This additional affidavit.
Yes, madam. Two affidavits are there. One is affidavit of service, and one is affidavit bringing on record
Yes.
the instrument of settlement, madam. So
Yes.
in a nutshell, my lord, my case is this. Foundation of two, I have two foundations. One is, my lord, it has been settled. So, and punishment is only, my lord, 5 years. And fine, which may extend to, in a case of a first offense, it may extend to 10 lakhs. 67 is two categories, my lord, first offense and second offense. This is a first offense. Apart from that, my lord, that order I have clearly, my lord, demarcated that portion, specific finding that based on the materials available today, this trial is going to end in futility. So my right of defense has been exposed. And apart from that, my lord, that judgment which he has quoted to bring home his argument, to justify this order, which is impugned, my lord, that part was excluded. That no fresh facts has come. You can order investigation, no doubt, you have the power. But where are the fresh facts? There was no facts at all. In a nutshell, that is my case.
So as a judgment, which says that if no fresh facts is brought before the London trial court, no order for investigation.
Do you respect, my lord, that specific judgment is 2019, it itself contains that parameters. Apart from that, my lord, I'm relying on further few judgments. I've given a book list.
But is it a case for quashing?
Quashing index, quashing because, my lord, that
Is it a ground for quashing?
it is a ground because my defense has been everything. There's nothing on record to show that I have. Apart from that, there's a weak point, my lord, but it's a point. Apart from that, since it is settled in the view of Narinder Singh's case, my lord, which went to up to the extent of quashing charges under 307 and also, my lord, Dimpi Gujarat. I pray for quashing, man.
Then Lakshmi Narayan.
my lord, Lakshmi Narayan, and I've not brought Lakshmi Narayan, my lord, Dimpy Gujral is with me.
Then,
Narendra Singh is-
then Sunil Gupta,
Sunil Gupta, ma'am, yes, ma'am,
that is,
yes, ma'am,
even if it's 307.
yes, ma'am. Narendra Singh is there, my lord, and Dimpy Gujral is with me.
Narinder Singh has been considered in Lakshmi Narayan case.
Yes, Lakshmi Narayan's case. But my
And-
lord, Lakshmi Narayan also takes care that it repeated the principles in Gyan Singh, which was laid down in Gyan Singh, my lord.
No, Gyan Singh and Narinder Singh all been considered, and
Lakshmi Narayan was passed.
Lakshmi Narayan has considered all these earlier decisions
Yes.
and then come to certain
Yes,
5 points,
yes.
enunciated 5 points of law.
Yes, yes.
And then thereafter, this Sunil Gupta has is there. Do you have all this?
I have Narendra Singh, then, and that apart, my lord, I have, as regards, my lord, power of the mind of the magistrate while conducting a trial, my lord. at
No,
considering
if
charges.
as per the law enunciated, if there are chances of the exercise is futility
My lord,
and chances of conviction is bleak.
Right.
In that case, 482 can be invoked
yes,
for quashing of the criminal proceedings.
Yes.
But your case is for reinvestigation,
yes, further investigation.
further investigation,
Further
I'm sorry.
investigation.
Further investigation, if you cannot show that these are the cases, if the court finds that there's no case for further investigation,
My lord,
in that case, will it be a ground for quashing?
it will be, my lord, with due respect, because the judgment which he has quoted, my lord, it speaks everything. This Binu Bhai, my lord. Binu Bhai has considered all the cases wherein, my lord, further investigation can be granted. And it has overruled a few judgments wherein, my lord, it was very clear, but it was overruled. But my lord, it is a constitution bench judgment, of 2019-17 SSC.
Which the learned trial court has relied on.
Yes, my lord. But
Eco-
that,
According to your learned court has correctly relied, but then misconstrued it.
misconstrued. Because, my lord, I have shown that no material was available. Leaving apart, my lord, he has a power. I don't dispute that. But that fact, it's a part of the judgment. He has quoted from the body itself. If fresh facts come to light.
But I don't agree that only the fresh facts are brought before the court, then only the further investigation will be directed.
My
Is it the requirement of the law?
my lord, since it's part of it's a judgment under 136, my lord. It's that magistrate did not write on his own, my lord. He quoted the Supreme Court order, and it is laid down there, my lord, if fresh facts come to light, for example. So it's not my argument, my lord.
It's only the ground
It's
for
a,
further investigation.
he has not, it has been taken into
No,
consideration,
forget about that, according to you.
my lord. It is not a
Is
ground.
it is only the fresh facts, what is brought before the court, then it will be a ground for further investigation. Is it the case requirement of the law?
I'll agree. to
Let
that.
us see the provision,
I'll-
CRPC.
In that case, my lord, I'd like to say this order from a different direction. There are, my lord, I admitted that it's a big.
No, that other grounds I may accept, this
Yes.
court may consider,
My lord.
but then the point which you have
Yes,
raised,
yes.
this is something you have to clarify.
No. my
You
lord,
have to
my
satisfy.
lord, to substantiate that point, my lord, I have
Yes.
to assail it from a different front. I have to assail and attack this
C-
from a different front.
CRPC.
To substantiate that fact.
Where is CRPC?
One 173, my lord. 173, subsection 8, my lord. I agree to that. There is an investigation provision further, but parameter is laid down. Or the domain of the police officer.
So it is not the requirement that only on the placing of new facts or the materials that the further investigation is required to be directed.
I'll beg to differ on that point. My lord will take up 173
Yes.
subsection 8.
Yes.
Nothing in this section, my lord.
Yes.
Shall.
Read.
Nothing in this section shall be deemed to preclude further investigation in respect of an offence after report under subsection 2 has been forwarded to the magistrate. And whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed under provision of section 2 to 6 shall, as far as may be, reply in relation to such report or report as they apply in relation to the report for the subsection 2. So, my lord, since it's
So for further investigation, according to you,
Well.
the officer in charge has to place further evidence or documentary or oral.
The word is very pertinent, but further investigation. Here also is used further investigation. But I think my limited knowledge, I can decipher is, my lord, that further investigation is in the domain of the IO or the police officer.
No, and this other than 73,
My lord.
the court has the power, the court can also direct to further investigation. If the requirements of the police
My lord.
officer in charge. Is it your submission that since the learned magistrate has had a findings that the trial, if it is allowed to proceed, will be
It is my
total exercise in futility, therefore it is a ground for quashing of the
Yes.
proceedings. Is it your
Because that
case?
observation should not have come from him. Because it exposes my defense, it takes away everything, my lord.
No, if it is exposes your defense, is it a ground for quashing?
In my humble opinion, my lord,
What this court understand is that in such a cases for quashing, if the exercise, the proceedings appears to be in futility, then only in that case.
Yes, my lord.
You may invoke 482.
Exactly. my lord.
But you are submitting other way around.
Yes, my lord.
You are saying that the findings of the trial court magistrate, it's amounts to exposing your defense,
My lord.
which may prejudice to you.
Right.
That cannot be a ground for
Because
quashing.
at Page 22, I have shown clearly that what is in the mind of the magistrate, other magistrate. He expresses his predisposition that it will end in conviction.
Where it
Page
is?
22, my lord.
Yes.
It starts even hypothetically. my lord. If
Hmm.
we were to assume that this court were to proceed based on the materials available today, there will be no materials to exhibit a proof at the stage of evidence in a trial. It would be an exercise in futility. He has expressed his mind in specific, clear words, my lord.
Okay.
I have nothing much to say, Lordship. In view of agreement, the understanding, what they call it, understanding arrived at, and the circumstances, the fact and circumstances, like the petitioner, I mean, the victim, after what they consider time has not appeared before this court. It appears if the trial is continued, even if it is continued before the trial court, I don't know whether she's interested in the case. So, given in light.
You agree to that it may in the exercise would be futility. Exercise will be futile. You agree to that?
I don't want to give a direct comment on that, but when by the whole exercise, I think it's best for me to leave to the wisdom of your lordship.
Don't leave it to this court. You make your submission. If you agree, we'll quash it. What's there?
Lordship,
If you have no objection, you are the prosecution.
lordship, since the complainant is not before here, even after notice has been served for a long time, it appears she may not be very interested to pursue the case in person.
No, when
Agreement, so.
other issue is when you have settled the matter, why did you jointly file the petition? If you are you relative? Are you related to each
I'll
other?
come to that. What has happened, man? After this unfortunate incident, they
Yes.
are not in a talking terms.
Okay. Then
You will
how
be
the agreement?
Agreement was made, my lord, prior to coming or filing this case, my lord. It was a part of the charge sheet also. After this agreement, there is no connection between them. It was only to answer to the appeal of their
See,
society.
apart from the legality, the settlement on the basis of settlement, the whole idea is to have a harmonious relationship in future
Harmonious, my lord, for the sake of
and
harmony,
a good relation. That is the basis of your settlement.
my lord.
So in that situation, only the High Court can invoke Other, apart from, besides, other issues,
Since their families have settlement.
yes.
So. but
Suppose
I
if you
tried-
are, if
I
you are
tried.
not, after this settlement, if parties are not in talking terms, what's the use of, what is the basis of settlement? There is no settlement as such.
No, my lord, this settlement.
It's
was
just,
reached
it's
upon,
just an
uh,
formality.
No, my lord, it was reached upon. due to
Once
the-
you settle means what? Settle, then you have to free mind voluntarily, and you have to
That-
decide
that I
to
admit,
live.
My lord is very correct. But in this case, my lord, since I'll just traverse in different aspect. The elders, my lord, or the families, they hold a command.
They have forced them.
Not forced, my lord, they have appealed that you should settle.
Yes.
So normally, if I have a fight with her, if our parents come down, you settle, we'll settle it. man. This is the practice prevalent. And normally, if we'll talk on technical terms also, there's no that kind of harmony is between the families, man. And as regards a joint petition, man, since I have made her a party, I have taken justice service. I have expected steps upon 2-3 times, man. And I have also served personally, which she has signed and received in her residence, man. But she is not coming. So that will also be, my lord, if I go for a fresh exercise, my lord, it will also, it will again also end up me in a tedious process, my lord.
Can you, even if she doesn't appear, can you obtain some affidavit?
Affidavit.
Because you see, normally, if you have settled the matter,
Right.
there should not be any kind of objection from either of the party.
Right.
And it has to be voluntary, and there should not be any. You just take one affidavit from the respondent.
May I submit, madam? To that respect, madam, I have all the judgment, madam. JK International. Constitution bench judgment.
Yes.
Says, madam, to continue with the prosecution. There are 8, madam, I can give a copy. My lordship, so. It's a 3 judges bench.
It's not constitutional bench judgment. If it is three
Oh, no,
judges.
well, I'm sorry, madam, because in our high court, madam, when honorable 3 judges sit, we have been in a practice, we have been taught
Where-
that it's
which-
done with the
which-
constitution.
Which high court?
Gauhati, my lord.
No,
I don't know, madam.
no, who says?
I'll take back what I have to name a few seniors then. Para 8, madam. But the situation here is different. As the accused approached the High Court for quashing the criminal proceeding initiated by the appeal, it may not that it may not be that the complaint should have been made a party by the accused himself in the petition for quashing the criminal proceedings. As the accused has shown no application in the case was started by the police. It is PWD the concern of the state to continue the prosecution, but when the complaint wishes to be heard in the proceedings and sought to be quashed, it would be a negation of justice to him. If he is so close from being heard, even after an incident was put in that behalf, what is the advantage of telling him that he will not be heard, even if the list of criminal proceedings, initial time will be quashed. He is no solace to be told that if criminal proceedings are quashed, he may have an right to take it to the higher forums. Well, putting it differently, madam, it's totally the prosecution charge sheet has been submitted, madam. It is the
See,
domain of the state, madam.
there are,
I
you are,
understand
if
correctly,
you are approaching this court for invocation of the inherent power under 482 CRPC on the ground of the on its merit
madam.
of the matter, like the cases where the chances of conviction is remote and no ingredients of the offense made out. That is something different which we can look into. But when you rely on the settlement,
Well,
if you are approaching the court on the basis of the settlement, the parties should, there should be a settlement in real sense. Not just
Settling for the
some,
sake of settling.
yes, for the sake of settling. That is, we,
The
I,
reason I initially started with that, I have two foundations. One way or the other. One was the settlement, other was the law point on merit. So I have a double approach, dual approach. Madam. One is settlement, it was even there is no whisper about this settlement. Only in the course of proceedings, madam, it was even I didn't annex. So only the course of proceeding, it was suggested to me from both the sides, madam, that I should bring it on record since there's a subtle way of there's a settlement. So only that reason I brought it down.
so in that case,
I was
your
proceeding
main
next.
trust would be that the learned trial court has exposed your defense while directing for
Further investigation.
further investigation. The court, the criminal proceedings should be set quash. That is the only
That is all.
only the
One of
ground.
the ground, my melody remains. Because I'm
That
taking instructions.
this court will examine. This may have it may go either way.
I'll take my chances. Madam.
That is one thing. Other thing is, if you are not taking the ground of settlement, then we'll examine it, but that is different. But if you are taking it, this court wants that, is it a real settlement? We're not forcing the victim or the respondent to come before this court since the service has been effected. But to rely that really it is to consider it as a settlement. This court is of the view that you should obtain some affidavit.
As that regards, my lord, I have to take instructions. from
Yes.
Matter before.
Otherwise I will decide the matter, whatever you have made a submission.
Well, I'm going to dispose of it.
So when do you want?
My lord, I have one matter fixed.
That is the suggestion of this court.
Yeah,
Because if you want to rely on the settlement,
I gracefully accept, my lord.
because
I
just
have-
because you have brought the settlement, the piece of paper, AG has fairly said that it was not exactly between the petition and respondent. It was at the instance of the family
My-
members.
It was.
So she might not have agreed to it, but under compulsion, she just nodded it maybe.
It might have, it might.
I also don't know, we also don't know, but then to make it sure that this is a settlement in legal, I mean, the real sense, in that situation only.
In that case, my lord, we'll kindly post this matter on 28/7 because I have some other matter we can.
28/7,
Both can come together.
okay. Because it's always better to have, see the pros and cons.
My lord.
Heard Mr.
D. Gogoi, my lord.
D. Gogoi, learned counsel to the petitioner. And also heard Mr. K. Angami, learned public prosecutor for the state of Nagaland. After arguing the matter for some time, the learned Mr. K. Gogoi, learned counsel for the petitioner, pressed for listing the matter on 28/7/2023. Mr. Prayer is allowed, list this matter on 28. Will not record all this thing.
Lordship, 28 is.
Let me try, because my lord, even if
Friday.
it, no, if he even doesn't.
28th July.
Yes, it's Friday. I don't know whether that is very practical.
No, my lord, I have another matter fixed. So by that, if I can bring an affidavit on record.
Hmm.
So his presence. should be
28th
necessary.
July.
It's Friday, so sometime,
Not, this is June.
no, July.
No, let me fix. Okay, let me fix.
He is seeking nearly a month.
Lordship.
So will not record
My lord,
what you are supposed to do. You take proper steps,
my lord.
list this matter also.
Item number 19.
Mr. Lordship.
Yes.
For the state respondents is appearing attending court one, your lordship. So I pray that it will become after the remaining matter has been over.
It's almost over.
Let's take a chance, Lord.
So what is there's a matter, this pleading is
Lordship,
completed?
It's for payment of errors, your lordship.
Okay.
And then the state is clearly admitted that we are eligible for that. And then they're just
But-
seeking for a certain period of time.
But there's no money.
No, lordship. They're just seeking for a certain period of time to complete the process.
Okay,
It's a simple matter only.
okay, so they want some time only
Yes, lordship.
to complete the process.
Lordship.
So we'll wait for them if you are agreed to that.
Yes, lordship.
Mr.
Subhamati.
Sabangmati Wali, learned counsel for the petitioner, submits that pleadings are completed. Please stop. As per the affidavit of the, is it correct? Should I record it?
Lordship.
As per the affidavit of the respondents, state
Paragraph 4 and 6, lordship.
the grievances raised by the petitioner has been considered. The only the respondent has stated that they should be given some more time to, sorry, the respondent has stated that they request some time to complete the process. I'm believing, I have not opened the
Yes,
brief.
lordship. Paragraph 4 and 6 is very clear.
And in view of that, this matter after 6 weeks.
No, your lordship,
They want to complete the process.
no, your lordship, it can be disposed of by granting certain period of time. So, your lordship, if it may come up on Friday, your lordship.
No, then will give us 4 weeks time. Then we'll see, we'll dispose it of. See, whether we direct it or not, they require some time to complete the process. Is not it?
Yes, lordship, I'm also doing lordship.
What do you say?
Yes, lordship.
Tell us. You suggest. No, this is, I'm passing the order on the basis of your submission. If that is the position,
Yes, lordship.
what, there's nothing to be determined.
Yes, sir.
If they concede it, and if they want some time, and if you agree to that, it will require some time to complete the process. So we wait for some time. By the time we'll say matter has become in process, you got the relief. Finish, is it?
Yes.
Is it the way right approach?
Yes, I'm okay with that, your lordship.
In view of the above, list this man after, well, not 6 weeks, 4 weeks,
Yes, lordship.
or less than that,
4 weeks, lordship.
4 weeks.
No questions. Orders, item number 22.
Twenty-two has been mentioned.
Yes, but,
Okay.
Yeah, please, Lordship. The counsel for the respondent to do some urgent work in Dimapur. He has went down to Dimapur. If your lordship,
So we'll wait for some time. That service report is yet to be received back. Huh?
Last order was.
last order, your lordship, date is 25/05.
Huh?
The last order was to be used for posts. And those contradiction in there. Sometimes they say they are going for all, sometimes they say they are going for only one.
Oh. Last order. Who is appearing for the respondent?
Inti Wapang, your lordship.
Huh?
Inti Wapang,
This is what?
ABC.
MSc appeal.
Yeah.
Who was mentioning the matter? Imti Wapang, he said he's appearing for only for
One.
One. What about the other respondents?
There are no information, Your Lordship.
This court on 25/5/2023. On the submission of the learned counsel for the appellant. Recorded that all these respondents are represented in this appeal. Mr. Therefore, directed for listing the matter for hearing. Today, Mr. Imti Wapang.
Your Lordship, my name is Enver, Your Lordship.
No, learned counsel for Mr. Imti Wapang submits that he is appearing only for respondent number
Yes.
1. In view of the above, the appellant to take fresh step to remaining respondents within 2 days. Because this office note is of February. So you take fresh steps. This after notify after 3 weeks. You take steps within 2 days for remaining respondents.
Fixed date may be given, Your Lordship. Fixed date may be given, Your Lordship.
After 3 weeks,
After 2 weeks.
3 weeks,
Lordship,
you just give
period
the
of on 18, Your Lordship.
18/7/2000.
07. Bless you.
The pleasure was.
Yes, sir.
Lord, the applicant is the retired Principal Director of Health and Family Welfare.
Yes,
She retired from the post in 2017
yes,
and she has received a summon notice from the SIT, Special Investigation Team,
yes.
under section 160 of the CRPC.
Hmm.
Although she has been summoned only as a witness, but then it is a notice under section 160.
Yes.
However, as an abundant caution, considering her stature in the society, she is applying for anticipatory bid and she has been summoned on 1st of July 2023 at 2 p.m. before the State Crime Police Station, that is at HQ Kohima, in connection with the case number 004 of 2014. It is a case of 2014, Lordship. And the Lordship will find from the notice itself on the
Page,
extreme
page,
left, address 2, page 10, Lordship.
page 10. Yes,
Under address 2, Dr. L. Sonso, CMO fact. During this period, the relevant period, the notice has been sent as a CMO fact 2011 to 2013. During this period, she was the CMO, Chief Medical Officer. She was the administrative head during this period. And the investigation which is going on is in connection with the misuse of a fund under NRHM, which comes under National Health Mission, Lordship. And as the mission is being implemented by under a mission director of that particular mission, that is implemented by in the district by MS, Medical Superintendent. And CMO is the only the administrative head in the department, in the branch, district office, and the principal director also is the administrative head in the department. Otherwise, all activities, all functions are being handled by the mission. That is a mission director, under the supervision of mission director. But then she has been summoned as a witness in connection with that case, which is an old pending case, I believe. This is a 2014 case. So I have made the undertaking and from paragraph 10 to 14.
Yes.
Although
Why you are apprehending arrest? It's 160 notice.
in view of the notice, I have never been to a police station in my life. So what will happen, I don't know. That is why she want to be secure. Otherwise, she has been just last year, she is also relieved as a deaconess in the church. She was working as a deacon in the Our Baptist Church, Kohima, Lordship, for the last 5 years. And she is the retired principal director. So considering her position and standing in the society, there should not be any blemish record in life. I am 69 years old.
Sir, what is the basis of your apprehension?
Basis of apprehension, there is no basis as such. But since I was working as the CMO during the relevant period, that is 2000.
It is 160. Why I'm saying 160 notice.
Yes,
Had it been 41 A, matter would have been different.
yes. It is just a notice as a witness only.
Yes, that's what I'm saying.
Yes,
So you have to show some apprehension. Why you are apprehending?
that's why, Lordship, in the address,
Had it been a notice under 41A as
yes,
an accused
yes,
or whatever, matter would have been different.
Yes.
160 notice.
although there is no guarantee that
Yes.
you are called only as a witness, but in the course of investigation, we never know. And there is no guarantee that since you are called only in connection with the section notice under section 160, you can never be arrested. That cannot be, Lordship. That's why, as an abundant caution, I have applied for the anticipatory bail.
Sir, as you know, when you are approaching for privilege of free arrest bail, you will have to show some apprehension that you may be likely to be arrested. You may likely to be arrested. But as a abundant question, it's very difficult for the court to decide. Anyway, what do you say?
Worship was rightly observed. I think,
Anyway, we'll see. We'll ask her to, he or she, ask her to, considering the status and whatever. She'll comply, she will appear on that day as directed, and interim will grant, considering her retired government officer and she being a woman. We'll call for the CD. Can you produce the CD? Okay. Heard Mr. City Jamil, Senior Counsel, assisted by Mr.
Aliba Muzakam.
You write, Learned Counsel for petitioner, applicant, petitioner. Yeah, applicant. Next period. This is an application under section 438 of CRPC, 1973. Praying for grant of privilege of pre-arrest bail in connection with the, what case is this? What PS case?
State Crime Police Station.
Crime Police.
State,
Page 7, prayer portion. In the interim.
in connection with the case number 004 of 2014 under section 406, 409, 420, 468, 467, 468, 471, 120B, 120 capital B IPC, 1860. Pending before the PS State Crime Police Station, PHK Kohima. A call for the city. Mr. K. Angami, learned council, learned public prosecutor for the state of Nagaland. Appeared on behalf of the state. Pending production of the case diary, the applicant, in the event of arrest, shall be released on bail. The bail bond of rupees 25,000, 20,000. Bail bond of rupees 20,000 with one surety of like amount on the following conditions. One, the petitioner, the applicant shall appear before the investigating officer on 1/7/2023. Before the appear before the investigating officer on 1/7/2023 as directed by the notice dated 23/6/2023. The applicant shall not hamper or tamper with the evidence or the witness. And third, the petitioner shall not leave the jurisdiction without the express permission of the concerned leave the jurisdiction of the concerned jurisdictional police station. List the matter after. List the matter on
20 Lordship, since vacation is coming.
okay 20
Lordship.
207/2023. Oh.
Computer section.